Good afternoon and welcome to this year's annual public procurement webinar. My name is Chris Tayton and I'm presenting with my colleague Emma Butcher. For those who haven't watched our previous webinars, we're both lawyers at Clarkslegal, specialising in public procurement law, and we advise both public bodies and businesses on challenges to procurement decisions. The Procurement Act 2023 continues to be the dominant feature of our annual update. We had planned the webinar to take place a few weeks before the commencement date, which should have been this October, 28th of October. As I'm sure you've heard, the government very recently put back the start date to the 24th of February next year. The ministerial statement announcing the delay is on this slide, and as practitioners we were a little surprised by the reason given. A need to update the National Procurement Policy Statement. The government has stated that the policy produced under the Conservative government does not meet the challenge of applying the full potential of public procurement to deliver value for money, economic growth and social value. Until this announcement, we had seen the National Procurement Policy Statement as we'd not seen it as having a decisive role in public procurement. It was an important feature in that contracting authorities had to have regard to it. However, the associated legal obligations were very limited. The original National Procurement Policy Statement already covers key procurement issues such as value for money, social value, opening the market to SMEs, and the need for contracting authorities to have necessary skills. It will be very interesting to see how the new policy statement differs. Most of today's webinar will look at changes being introduced by the new Act. The Act runs to over 200 pages, it has over 100 new sections and several schedules. The presentation will necessarily therefore be quite high level, but should still be useful. At the end, we'll provide a quick roundup of this year's other legal developments. They relate to the existing pre-Procurement Act law, but they're still important. The existing regulations remain in force for now and will continue to have relevance after the new Act comes into force. The reform of public procurement law has been on the cards for several years. Going right back to the Brexit referendum, public procurement was targeted by the Leave campaign. It was claimed that £1.6 billion and 1.9 million days a year could be saved by amending the procurement rules and cutting through EU red tape. We always felt that some of this criticism was rather unfair. The fact that the UK were heavily involved in the development of the EU procurement regulations and the government decided to implement a gold-plated version into UK law rather than simply the minimum EU procurement standards was generally overlooked. But that is a matter for history now. The new Procurement Act is certainly being promoted as a Brexit dividend. In the foreword to the Green Paper, Lord Agnew, then Minister of State for the Cabinet Office, said, "The end of the transition period provides an historic opportunity to overhaul our outdated public procurement regime. I have seen myself that these rules have made it much harder for us to create opportunities for innovative companies to win business and improve public services, or for public bodies to exclude suppliers that have performed poorly in the past. Now we have an opportunity to design something that delivers for our communities and our businesses. That is something everyone working on this can see as a dividend from the UK leaving the EU, no matter how they voted in the referendum." Starting next year, we'll find out whether these lofty ambitions will be achieved. We start by looking at what the government is hoping to achieve. There is a lot of information about this on the Transforming Public Procurement page on the government website. The government has told us that its primary objectives are to create a simpler and more flexible commercial system that better meets the country's needs while remaining compliant with our international obligations. To open up public procurement to new entrants such as small businesses and social enterprises so that they can compete for and win more public contracts. To embed transparency throughout the commercial life cycle so that the spending of taxpayers' money can be properly scrutinised. First, the transparency ambition. The government has told us that one of the goals of the procurement bill is to create a fully transparent procurement system. We want everyone from citizens to ministers, large companies to sole traders, those responsible for multi-billion-pound defence contracts, to people buying stationery on behalf of district council, to be able to view, search and understand what the UK public sector wants to buy, how much it is spending and with whom. The government acknowledges that the current procurement system is already very transparent. Anyone working in public procurement will be aware of the large volume of information you need to provide. The new rules will go further. As we will see, there is a substantial increase in the number of notices public bodies will be required to give during the life cycle of public procurement and the information bidders will receive. This is not just at contract award stage. There is an expansion of the type of information public bodies need to disclose pre-tender and during the performance of the contract. And this will be supported by a single electronic platform accessible by everyone. Next, the government's innovation ambition. The government has told us, our ambition is that over time, these developments will make public procurement into one of the most powerful levers to drive innovation nationally, nurturing creativity and growth in local business communities, and at the same time, substantially improving the effectiveness of public services. This is where the government sees the real benefit and upside in the reforms which will deliver the dividend, the Brexit dividend. It's believed that new procurement processes are innovation friendly. In particular, there is a great emphasis on engagement with the market before going out to tender. SMEs are considered important in the drive for innovation, and there is an obligation to deal with the barriers to SME participation in tenders. Training and guidance is provided to contracting authorities to ensure those entrusted with delivering procurement are trained in how the new rules can be used to promote innovation. Although the changes brought in by the 2023 Procurement Act are not as radical as expected, the procurement rules are changing substantially. I'll now hand over to Emma to explain the detail of those changes.
Thank you. So that is how we got here, and now we will turn to the new Act itself. The Act received royal assent almost a year ago, last October, and shortly prior to the general election, the government had announced a go-live date of the 28th of October this year. But as Chris has already explained, earlier this month, the implementation of the new Act was delayed until early next year. So the new go-live date is now the 24th of February 2025. We have had some secondary legislation, the Procurement Regulations 2024, which were passed in May. They include a lot of the detail around the new regime. There will be some further secondary legislation to come before the go-live date. So what are the transitional arrangements? Well, the Public Contracts Regulations or Defence or Utilities Regs, if you're dealing with those, will continue to apply to all new procurements which are commenced prior to the coming into force of the new Act. And commenced basically means publishing a contract notice. An authority publishing a prior information notice before February won't count unless they published it way back in May 2023. The old regime will continue to apply to all existing contracts and framework agreements prior to the coming into force until they cease to exist. So if a framework agreement, for example, is awarded for 5 years with a 2-year extension just before the new Act comes into force, the old regime will still apply to that contract for another 7 years, including to things like awarding call-off contracts under the framework, modifying the framework or extending it. So we won't be able to forget the old law just yet. The government has been putting a lot of work into the transition process over the last year, and there is a lot of guidance available on the gov.uk website, both specific transition guidance and also materials on most aspects of the procurement lifecycle, with some more still to come. There are also some training videos and e-learning modules which are worth your procurement teams having a look at. The financial thresholds at which the new Act applies are not changing from the current regime. The thresholds for the different types of contract are on the slides there. They are reviewed every 2 years, and the next review is due in January 2026. So what is changing? The first big change is that the Act brings all of the procurement rules under a single umbrella. It replaces all the different pieces of legislation we have under the existing regime, the public contracts regs, concessions, defence, utilities. These are all very similar, but they have some subtle differences. So the fact that all procurements will now proceed under the same set of rules is a welcome bit of streamlining. But that said, the Act does have different parts dealing with what it calls special regime contracts, and these will include utilities and defence. So there are still some sector-specific rules. The other big change is that the new Act scraps the current regime, where we have 6 different procedures to choose from: open, restricted, competitive, dialogue, etc., and replaces them with a new single competitive tendering procedure. This allows more flexibility than the current regime. The contracting authority can either use a single stage open procedure with no restrictions on who can enter. or it can use any other competitive procedure which it considers appropriate, as long as it's proportionate to the nature, complexity and cost of the contract. Now, this really is one of the biggest changes, the ability of contracting authorities to design their own procurement procedure. The idea is that they'll be able to tailor the procedure to their needs. This might mean, for example, incorporating a two-stage assessment process. It might mean negotiation, inviting best and final offers, using product demonstrations, site visits, things like audits and checks as part of the actual assessment. The possibilities are vast. It will be really interesting to see how authorities are going to take advantage of this. I suspect, at least to begin with, we'll see most authorities, particularly the smaller ones, sticking with the standard single-stage open procedure. Perhaps it's only in the more specialised sectors like defence that we'll start to see more bespoke procurement design. It will have to be authorities with deep enough pockets to defend any challenge over the basis of the design who pioneer the way. But the government has said it will be publishing a range of template documents for different types of procurement and complexities. We're still waiting to see exactly what those look like, but the government has published guidance on the competitive tendering procedure, which includes a series of annexes setting out a range of suggested procedures that authorities could adopt. And those incorporate various different levels of negotiation. I've included the outline of them on the slide there. So far, they look quite similar to the existing procedures we already have, so not that radical. One important thing to note from a bidder perspective is that if you do come across a new and innovative procurement procedure and you have concerns that it isn't fair, maybe because it favours a particular competitor in the market or it discriminates against your business in some way, you need to seek legal advice and challenge it at an early stage. That's because the very short time limits for bringing a legal challenge to a procurement award aren't changing. You have to start legal action within 30 days of discovering a breach or a potential breach. So please don't sit on any concerns, come and talk to us. The next major change is that we've got some new overarching procurement principles or core procurement objectives. Under the current regime, the European Treaty contains 3 fundamental procurement principles: transparency, proportionality, and equal treatment or non-discrimination. These are going, and in the new Act, we have 4 core procurement objectives, which are on the slide there: delivering value for money, maximising public benefit, sharing information to allow suppliers to understand policies and decisions, and acting with integrity. From a practical perspective, is this really a significant change? Well, not really, in my view. The principle of transparency is essentially retained in the duty to share information. There is also still an express duty of equal treatment. We don't any longer have a general proportionality obligation, but there are still requirements to have regard to proportionality at various specific stages. One thing that is new in the Act is a duty to have regard to SMEs and consider how the barriers to their participation can be reduced. This is a positive, but it does feel like it could be vulnerable to being a bit of a tick box exercise for contracting authorities without actually implementing any meaningful change. There's a question mark for me over whether it's really an enforceable duty. Is any SME actually going to take legal action over this? If you're an SME and you think that a contracting authority hasn't had due regard to you in designing their procurement, then the onus will be on you to challenge it. And given the cost of legal action and the fact that this is action which you're probably going to have to take before you've even found out the outcome of the tender, are any SMEs really going to do this? But it will be interesting to see how this duty actually operates in practice. The Act makes clear that these core procurement objectives apply for the whole lifetime of a public contract, and that means setting up the tender, running it, awarding the contract, and then managing the contract itself. Let's move on to look at what contracting authorities will actually need to do in running a tender under the new regime and the different types of notices they will be required to publish. At the moment, and since Brexit, notices are published on the Find a Tender service. Under the new Act, the government will be launching the new central digital platform. And this will basically comprise 2 systems accessed via a single login. The first will be an enhanced version of the existing Find a Tender system. That will be used by contracting authorities for the publication of all the different kinds of notice they will need to publish. The second bit will be the new supplier information service. This will be used by bidders to submit their core supplier information, which means their basic contact details, information on economic and financial standing, any exclusion grounds. which will be a welcome bit of streamlining because contracting authorities will be able to retrieve all of this information from the central digital platform each time, rather than you having to put it together every time you submit a tender. Looking now at the different types of notices contracting authorities will be publishing. First of all, we've got the alert the market stage. Some authorities will need to publish what's called a pipeline notice at the beginning of a financial year, where they think that they'll be spending more than 100 million in public contracts that year. That's got to be published within 56 days of the beginning of the financial year. Next, at the moment, contracting authorities alert the market to an upcoming opportunity via a PIN or prior information notice. Under the new Act, these will be replaced with two different kinds of notices: planned procurement notices under Section 15 of the Act and preliminary market engagement notices under Section 16. The purpose of a planned procurement notice is to alert the market to an upcoming opportunity. It's not compulsory to publish one, but if you do, it may enable you to shorten the period for which a competition has to remain open. And then a preliminary market engagement notice is to alert suppliers to the fact that you intend to or that you have carried out a market engagement exercise. And contracting authorities must publish one of these if they have carried out any market engagement. If the procurement is caught in the crossover of the two regimes and an authority has already published a prior information notice before February, then they won't have to publish another preliminary market engagement notice. They can rely on the existing PIN. If the authority doesn't need to do any market engagement, then they can proceed straight to tender and publish their new tender notice under Section 21 of the Act, informing suppliers that they are intending to award a public contract and inviting them to submit a tender. And as I mentioned earlier, the procurements will now take place via the new single competitive tendering procedure. So the new procurement regulations 2024 deal with all of the detail of what these notices need to contain. But we are still waiting for the template documents, and once they are published, it will be worth familiarising yourself with these so you can be ready for the new Act and what tenders might look like. Along with the tender notice, authorities also need to publish at the same time the associated tender documents, which basically means everything else: the specification, the award criteria, the scoring methodology, etc. On timing, it's up to the authority to decide what the time limit should be for suppliers to respond, taking into account the nature and complexity of the contract. But the time limits do need to be the same for all suppliers because of the equality duty, and there is a minimum time limit of 25 days or 10 days for urgent contracts. Now on to the basis of the award. We have a slight change here. We are moving from meet to MAT. Under the current regime, contracts must be awarded to the most economically advantageous tender, but we are getting rid of that economically. What does that mean in practical terms? Well, you can't ignore price altogether because one of the core procurement principles is still delivering value for money, and there is an obligation to design the tender in a way which is proportionate to the contract. But it does give authorities more flexibility to take into account matters other than price, for example, social value. And we may start to see a shift in the weightings that start to come out under the new Act. In terms of the actual award criteria, there are no real changes here. Authorities still need to ensure that the award criteria are linked to the subject matter of the contract. But there is a new express provision in the Act which makes clear that in most cases authorities will be able to include criteria on supplier experience, qualifications and ability. And criteria will still need to be sufficiently clear, measurable and specific and comply with the rules on technical specifications, which are broadly the same as now. So for example, not referring to a particular brand or model if a generic description will do. And criteria also need to still be proportionate, having regard to the nature of the contract. So this doesn't really represent a big change from the current law. We do have a slight change in the law on selection criteria under the new Act. At the moment, many tenders you participate in will have a selection stage first. Selection criteria will now be called conditions of participation, and authorities can't use them if they're opting for the single stage open procedure, because obviously that has to be single stage. But they will be able to incorporate a selection stage if they're using another kind of competitive flexible procedure. So the new conditions of participation will only be allowed if they are a proportionate way of ensuring that suppliers have the financial capacity and the technical ability to perform the contract. And there are some things that authorities cannot include as conditions, which are mostly designed to ensure that SMEs are not excluded, such as they can't require audited accounts unless the company is already one, which would require them anyway. They can require the supplier who wins the contract to have insurance in place covering the contract performance, but they can't require it to be in place before the contract award. At the moment, the use of selection criteria is quite circumscribed by the CCS Standard Selection Questionnaire, but there is some anticipation that conditions of participation will be more flexible for new procurements under the Act. So let's see. Abandoning a contract. Under the current regime, there's no requirement for authorities to publish any kind of notice when a tender is abandoned. There's only an obligation to inform suppliers of the decision as soon as possible. That's changing. Under the new Act, you will have to publish a procurement termination notice if you abandon a tender. But there won't be any real practical changes to the implications of abandoning. It will remain the case, as now, that authorities can reserve the right in the procurement documents to abandon a tender at their discretion, and there will be very limited scope for a supplier to challenge that, as frustrating as it can be when a tender is abandoned after you've put a lot of time and cost into preparing your bid. Excluding suppliers. This was one of the big headlines when the government first published its Green Paper on reforming public procurement, that they were going to make it much easier for authorities to exclude suppliers. This is an area where the Grenfell disaster was quite influential, because in the aftermath you had these problematic suppliers who were continuing to bid for new work, and there was no legitimate way for authorities to exclude them. But what we've actually ended up with in the new Act is not that radical. The current regime, where we have mandatory and discretionary grounds for exclusion, more or less remains. We have a slight change in terminology, so that if a mandatory ground applies to a supplier, they will be known as an excluded supplier. If it's a discretionary ground, they will be an excludable supplier. And as with now, if a supplier is excluded, then authorities must prevent them from participating in tenders and must not award them contracts. If they're excludable, then the authority has a discretion and may prevent them from participating. The new mandatory grounds under the Act are basically the same as we have now, things like terrorism and bribery. There are a few new discretionary grounds, including one for prior poor performance. This is quite limited in scope. It only applies if a supplier has had an existing public contract terminated or has breached the contract such that it has given rise to damages or a settlement agreement with the authority, or has failed to improve their performance following the authority serving a formal contract improvement notice on them. So it is a high threshold, and I don't expect we'll see the floodgates open to lots of suppliers being excluded for poor performance. If you are unlucky enough to be subject to an exclusion ground, and the circumstances which led to that are likely to recur or continue, then you can be placed onto the new central debarment list. I won't go into all the detail on that now, but there is a process whereby if you're excluded from a tender, then the contracting authority will refer you to the procurement review unit for investigation. If that investigation finds that the circumstances which led to your exclusion are likely to recur or continue, then you'll be placed onto the central debarment list. Suppliers do have the right to appeal the decision, but the timescales are very short, 8 working days. Because being excluded from a tender in the first place is the trigger for being investigated, it will be important for suppliers to consider challenging their exclusion at that stage, rather than waiting until you're facing being placed onto the central debarment list. Another important point for suppliers is that if you're using subcontractors, then your subcontractor being an excluded or excludable supplier is enough for you to be excluded as well. But authorities do need to give you a reasonable opportunity to replace them before they exclude you. And finally in this section, direct awards. Under the current regime, we have Regulation 32 of the Public Contracts Regulations, which we saw fairly liberal use of during the COVID-19 pandemic and consequently numerous challenges. The new Act does make some changes to the rules on direct awards. Regulation 32 currently restricts this to situations of extreme urgency, where that urgency cannot be attributed to any failure of the public authority. But under the new Act, Section 42 will permit direct award where regulations are made by the government permitting this in order to protect human, animal or plant life or health, or to protect public order or safety. This means effectively that the decision is taken away from individual public authorities and will rest with the government. If the government does publish any such regulations, they may restrict them to certain specified public contracts, such as in the healthcare sector, and they may also include other conditions or limitations. Because of the need for government regulation, I think we will only see this being used in cases of another pandemic, for example. It's probably not going to be very widely used.
Notification of the results of a public tender is a critical part of the procurement process. Bidders find out whether they have won or lost. Contracting authorities find out whether their procurement award will be challenged. Where a procurement award is challenged, there is a difficult balancing act involved in working out how best it should be resolved. We have the public interest in the challenge being resolved as quickly as possible to avoid expensive delays in the award of important public contracts, but we also have the rights of bidders to have their complaints about the procurement award properly determined by a fair legal process. The reforms proposed in the Green Paper were very radical solutions to these problems. They would have fundamentally changed the current system for challenging procurement awards. The rights of bidders, in particular, would have been significantly watered down. To the disappointment of some, the new procedures of the Procurement Act are nowhere near this radical. In fact, in our view, the new rules are not significantly different to the old ones. We start by looking at the notification obligations that apply once a contracting authority has decided which bidder has won the public tender. The current rules require the contracting authority to send all bidders a notice communicating the outcome of the tender. This is under Regulation 86. The letter to the unsuccessful bidder has to include both its scores and the winning bidder's scores. It also has to include an explanation of the characteristics and relative advantages of the successful tender. This latter requirement is neither clear nor popular. In our experience, practice varies considerably between different contracting authorities as to the amount of detail provided to unsuccessful bidders. Often bidders believe they are receiving too little information, and contracting authorities believe bidders are asking for more than they are entitled to. There is some guidance in the Crown Commercial Services Guidance on the Standstill Period, but again, compliance is not uniform between contracting authorities. The 2023 Procurement Act is bringing in some changes to this area. The contracting authority now has to issue two notices at this stage. First, the contracting authority has to provide an assessment summary to each tenderer. The assessment summary received by an unsuccessful tenderer will include information both about the contracting authority's assessment bid and the successful tenderer's bid. The detail of what is required to be included in the assessment summary is found in Regulation 31 of the Procurement Regulations. A lot of information will need to be provided, much of it uncontroversial and not dissimilar to the current rules. Much of it repeats what bidders already know from the ITT about the tender rules for the evaluation of bids. There is, however, helpful clarification about the information to be included about the evaluation of the winning and losing tenderers' bids. As well as receiving a breakdown of scores by reference to each criterion and sub-criterion, the rules now clarify that bidders will receive an explanation for each score by reference to the relevant information in the tender. What bidders won't receive is an explanation for why they didn't receive the next highest score for their response to individual questions. That requirement had been in the draft regulations, but was left out following the consultation process. We understand that best practice still supports including this information. Few, however, will be disappointed that it is no longer necessary to describe the characteristics and relative advantages of the successful tender. There is no requirement now for contracting authorities to explain the difference between bids. However, the government's guidance does stress that a supplier reading the two sets of information alongside each other will be able to ascertain the relevant advantages. When the current proposal is implemented, it will certainly underline the need for contracting authorities to undertake and document the evaluation stage of the tender very robustly. Any mistake in the assessment summary could form grounds of a challenge. As well as sending an assessment summary to the bidders, the contracting authority also has to publish a contract award notice to alert the market that it intends entering the contract. This can be done on the single electronic platform the government will be producing. Details of the information that needs to be included in the contract award notice is found in Regulations 27 to 30 of the new procurement regulations. The notice needs to include fairly extensive information about the tender, including who has won. It's beyond time available today to go through all this detail, but importantly, the contracting authority also has to publish the identity of unsuccessful tenderers in contracts worth more than £5 million. This might not go down too well with unsuccessful tenderers. The notice also has to confirm that the assessment summaries have been sent out and the end of the standstill period, which is the next subject. The 2023 Procurement Act retains the concept of a standstill period. This is the short period of time allowed to bidders to review the tender outcome and decide whether to challenge the award before the contract is entered. Importantly, if a bidder issues legal proceedings during the standstill period, that automatically suspends the contracting authority's right to enter the contract with the winning bidder, and we'll come back to that later. The current rules are found in Regulation 86, the Public Contract Regulations, and provide for a standstill period of 10 days, assuming the notice is sent electronically, which is almost always the case. The new rules are found in Section 51 of the 2023 Act. They contain a small but important change. The mandatory standstill period is now 8 working days, which in practice is quite significant. The approach we often currently see is for contracting authorities to send out award notification letters to bidders on Fridays. That means the 10-day standstill period contains 2 weekends and expires on the Monday after the second weekend. In practice, this often leaves bidders operating under tight time pressures when making important decisions about the contract award. And from experience, bidders will be very grateful for this small increase to the length of the standstill period. As mentioned, the new rules under the new Act retain the concept of an automatic suspension if legal proceedings are issued and notified to the contracting authority. This is an important remedy for unsuccessful tenderers who want to challenge a procurement award, as it prevents the contract being entered with the successful bidder, initially at least. Whilst the suspension remains in place, this gives the tenderer the opportunity to argue that the procurement decision was wrong and either that it should be awarded the contract, or alternatively that procurement should be rerun. Again, there is a subtle but important change introduced by the new Act. Under the current rules, issuing and giving notice of legal proceedings to the contracting authority before the contract is entered will suspend the contract award. And potentially that can happen after the end of the standstill period if the contracting authority has not yet signed the contract with the winning bidder. Under the new Act, issuing proceedings once the standstill period has expired will be ineffective, even if the contract has not been entered. The 2023 Act does not record whether parties can extend the standstill period. It's not prohibited by the Act, and in our view, extensions are likely to be effective, but this may need to be tested before the courts. In practice, this change again really underlines the importance to bidders of reacting very quickly if they receive an award notice, or more accurately an assessment summary, which they believe is wrong. Currently, there is some flexibility in the timing of bringing a legal challenge. The sort of arrangements we currently see where contracting authorities simply agree not to enter the contract whilst the procurement award is considered won't work. Either you need to issue legal proceedings in the 8 days allowed under the standstill period, or possibly you can agree a formal extension to the standstill period before it expires. Both the current rules and the 2023 Act provide tenderers in above-threshold procurements with a civil remedy if a contracting authority breaches its procurement obligations. In the Green Paper, which set out the original proposals, radical reforms were suggested to the court process. There was the suggestion of setting up a specialist procurement tribunal dedicated to dealing with lower-value procurement disputes. It was also proposed to introduce a tailored court procedure designed to make the review of procurement decisions quicker. The aim being on focusing on remedies before the contract is entered, rather than leaving parties in lengthy damages disputes after the contract is entered. This proposal has been very much stepped back from. For now, the new Act maintains the legal process under the current regulations. The High Court continues to have jurisdiction over procurement disputes, and there is no specialist procurement procedure. The former government did indicate that they would continue to explore options for faster, more accessible routes for procurement challenges, but that changes to civil procedure would be subject to review by the Ministry of Justice and the Civil Procedure Rules Committee. So possibly this is one for the future. If an unsuccessful bidder issues legal proceedings and brings into play the automatic suspension, the contracting authority has the right to go to court to ask for the suspension to be lifted or modified. That fundamental right remains unchanged. Under the current rules, the court applies the American sign-of-it test to decide whether the suspension should be lifted. A key feature of that test is whether the bidder can be adequately compensated for its losses by receiving a damages award, rather than the contract award remaining suspended. In most cases it can, and for that reason, usually the court did lift the automatic suspension. This left the parties involved in an expensive and lengthy legal dispute over damages. One of the objectives of procurement reform was to promote early resolution of claims in preference to damages claims. In other words, achieving resolution before the contract was entered, which would be during the period of suspension. The new Act creates a new test for the court to apply to determine whether the automatic suspension should be listed. The text of that section is set out on this slide. We don't have time today to explore it in detail or how it will be applied in practice. That will need to be determined by the court, and which we expect will happen very shortly after the first tenders are run under the new Act. As an initial observation, there are a number of features of the new test which look very similar to the current American sign-of-it test. The issue of whether damages are an adequate remedy for suppliers remains a relevant factor in section 102.2. The other factors are not dissimilar to the issues the court considers when deciding whether the balance of convenience is in favour of lifting the suspension or leaving it in place until trial. Significantly, the Act does not give primacy to any of these factors, so the exact meaning of this section will not be known until we have a court judgment. Both the current regulations and the new Act give the court the power to order a wide range of remedies. The pre-contractual authorities are listed on this slide. Today we just have time to look at two of the remedies. Firstly, damages. This often ends up being the remedy a dissatisfied tenderer is forced to pursue if the court lifts the automatic suspension. If successful, damages would generally compensate a bidder for the loss of profits on a contract that should have been awarded. And this is another area of procurement reform where initially very significant changes were proposed. In the Green Paper, the proposal was that the maximum damages awarded to a bidder who successfully challenged a procurement decision was 1.5 times their wasted bid costs. For large procurements in particular, this would leave bidders substantially undercompensated for missing out on contracts they should have won. The government decided that a cap could have unintended consequences that were more problematic than the issues the cap was seeking to address. As best we can tell, damages as a remedy remains unchanged under the new Act. We do not yet know whether the current requirement to demonstrate the breach of the procurement duties is sufficiently serious to justify a damages award, which was originally based on EU law, will carry over to the new Act. We suspect it will, and again await the first judicial decision on damages in a procurement case subject to the new Act. Another important remedy under the current law is the remedy of ineffectiveness. This is currently available where the contract award involves serious breaches of procurement procedure. The full list is on the slide and includes cases where a public contract is awarded without being advertised, or during the standstill period, or during a period when the automatic suspension applies. The new Act introduces a change of name. The new remedy is a set-aside award rather than ineffectiveness. The wording and structure of the new Act differs from the existing regulations, but the circumstances in which the remedy applies are broadly the same, as acknowledged in the government's guidance. The new Act continues to recognise that procurement disputes need to be resolved quickly to allow, wherever possible, public contracts to be entered quickly to enable important public services to be provided. The current system requires legal proceedings to be issued within 30 days of when the tenderer first knew or ought to have known the grounds for starting the proceedings had arisen. The court has the power to extend that time to up to 3 months, although that only applies in very limited circumstances. Failure to meet these time limits means that your claim is time barred. The same rules on time limits have been included in the new Act. The time limits for the court to set aside a contract entered by a contracting authority, the current ineffectiveness remedy, have changed very slightly. The 6-month long stop starting from the date the contract was entered still applies. That's under Regulation 932B of the current regulations. However, and if you don't find out about the contract until after the 6 months period has expired, you have no legal remedy, however unlawful the award. There is a slight difference to the application of the 30-day time limit. Under the current rules, 30 days only starts to run if the contracting authority publishes a contract notice or tells you about the contract. The test under the new Act starts the 30 days running from when the supplier first knew or ought to have known about the contract. In other words, irrespective of whether the contracting authority has published a notice or told the supplier about the contract. So that was a quick overview of the key changes and non-changes included in the new Act and the new procurement regulations. We didn't have time to cover everything, but hope to have captured the most important points. And we end with a quick roundup of the most important court decisions in the last 12 months or so.
All of the case law we're going to talk about now is from the last 12 months and is under the current regulations. This will remain relevant as the existing regime will continue to apply to procurements commenced before February. And even when the new Act does come into force, case law on the regulations is likely to remain relevant and persuasive as many of the same concepts are going to continue to apply. The first case I'm going to talk to you about is Lancashire County Council and Brookhouse Group Limited. And this is about the time limits which apply to claims for a declaration of ineffectiveness. As we've just talked about, declarations of ineffectiveness, which are soon to become set aside under the new Act, are a relatively rare remedy which only apply for very serious breaches of the regulations, such as failure to advertise a contract that should have been advertised. And the usual time limit for procurement claims, which we've mentioned a few times, is a strict 30 days from the date of knowledge, but the time limit for bringing a claim for a declaration of ineffectiveness can be longer, up to 6 months, depending on the circumstances. If the contracting authority has not held a competition but has published a contract award notice on the Find a Tender service, and that notice explains why the contract was awarded without inviting tenders, and then the time limit is 30 days from the date of that notice. If the contracting authority has held a competition and has told bidders about the conclusion of the contract and the reasons why it was awarded or why their bid was rejected, then again the time limit is 30 days from when the claimant was told. But in all other cases, the time limit is 6 months from the date that the contract was entered into. The rationale for that being, if there's no contract award notice and suppliers aren't informed, then they shouldn't be held to a strict 30-day time limit, because how could they have known about the contract to challenge it within that time? So what happened in this case was that Lancashire and Brookhouse jointly owned a site, and in 2019 they entered into negotiations to develop it, but ultimately those were unsuccessful. And then later in 2022, Lancashire entered into a development agreement with another company, which was a subsidiary of a company to whom they had already awarded another development contract. And Lancashire believed that they had entered into the new agreement under or pursuant to that earlier agreement with the parent company. So they thought that the regulations didn't apply and they didn't need to hold a competitive tender. They did tell Brookhouse about the agreement though, and gave them a detailed explanation of why they thought that the regulations did not apply. Around 4 months after that explanation had been given, Brookhouse issued a claim seeking a declaration of ineffectiveness. And Lancashire argued that the claim should be struck out because they said, well, we told Brookhouse about the contract, so the limitation period was 30 days from when we told them. But the court said no. They said there are 2 circumstances in which that 30-day limit applies. The first is where you've not held a competition but you have published a contract award notice, but Lancashire didn't do that, so they couldn't rely on that ground. The other is where you have held a competition and you've provided the bidder with reasons. But Lancashire couldn't rely on that ground either because they didn't hold a competition. The reasons that they gave weren't the type of reasons that this ground requires. So the court said the time limit was 6 months and Brookhouse's claim was therefore in time. Lancashire appealed that decision, but the Court of Appeal upheld the lower court's reasonings. This is one of the few cases on ineffectiveness, so it's useful to have some clarification of those time limits. The next case is also about time limits, but this time the usual 30-day one. And that 30 days runs from the date of knowledge, that is, the date on which the bidder knew or should have known that the grounds for starting the proceedings had arisen. So what exactly does that mean? In this case, the claimant, Oracle, had been providing facilities management services to St Bart's under a call-off contract under a framework agreement. And in February 2023, St Bart's appointed another supplier called Assist to provide them with fire warden services. And then in June 2023, they awarded Assist a contract, which they backdated. And they said this was also a call-off contract under the framework agreement. At some stage in around July or August, Oracle found out about this and they started asking questions. And they weren't very satisfied with the answers to those questions, which led to them issuing a claim against St Bart's in October, arguing that the contract awarded to Assist was unlawful because it hadn't followed a competitive tender and it didn't fall within the scope of the framework agreement. St Bart's argued the claim was out of time because they said the 30-day time limit had already expired by the time the proceedings were issued. And so they asked the court to dispose of the claim by way of summary judgment, that means without a trial. As I just mentioned, the test of when the 30-day time limit starts to run is whether the bidder first knew or ought to have known that grounds for starting the proceedings had arisen. It's quite a stringent test. If the information was available, for example, via a notice published on Contracts Finder, then you will be treated as having ought to have known about it, even if you didn't actually know as a matter of fact. In this case, there was a dispute about when Oracle knew or should have known, and they had been asking questions of St Bart's via their solicitors, but there was a question mark as to exactly when their solicitor would have received and read a response which St Bart's had sent, and whether the knowledge of Oracle's solicitor could be attributed to Oracle themselves. Ultimately, the court didn't decide those questions, but it found it was not sufficiently clear when Oracle acquired the knowledge that the contract had been awarded. Therefore, it was not appropriate to dispose of the claim on a summary basis without a trial. So Oracle's claim continues. The next case is about disqualification of bidders. Optima Health was an occupational health provider and they submitted a bid to the DWP for a call-off contract under a framework agreement to provide an occupational health and employee assistance programme. And their bid was rejected for non-compliance because they hadn't complied with a requirement not to submit a pricing schedule which exceeded the pricing contained in the framework agreement. Optima had scored the highest mark in the tender overall and they would have won if they hadn't been disqualified. In fact, there was only a single compliant bid, and so the contract was awarded to that bidder. Optima then brought a claim challenging that disqualification, arguing that the requirement not to exceed the framework pricing schedule was not clear and transparent, and it didn't spell out that the consequence of non-compliance would be disqualification. They also argued that the DWP had not properly exercised their discretion to disqualify. Unfortunately for Optima, their claim was dismissed. The court found that there were clear explanations in the invitation to tender documents, which made it very clear that there was a risk of disqualification if the requirements were not complied with. On the exercise of discretion, the court found on the evidence that the DWP had carefully considered all options, including whether they should allow bids to be resubmitted or whether they should reduce Optima's pricing, and whether they should disqualify them. But the DWP had decided, probably rightly, that allowing Optima to resubmit or reduce their pricing would breach their duties of transparency and equality to the compliant bidder. Finally, the court said that DWP had not acted unreasonably, disproportionately or irrationally in disqualifying Optima's bid. Ultimately, the non-compliance was Optima's own fault and they should have been alive to the risk of disqualification. So this case is another salient reminder of the importance of adhering to all mandatory requirements. Don't expect the court to rescue you from errors.
The next case is Brace Yourself versus NHS England. This is the most recent in a line of decisions following NHS England's decision not to award a contract for orthodontic services to Brace Yourself. And this was another case where the final scores awarded to the bidders were very close. Brace Yourself was awarded 80.25%, the successful bidder received 82.5%. At first instance, the court determined that NHS England had made a manifest error in the marking of Brace Yourselves bid. They should have received 4 marks rather than 3 marks for one of their responses. That meant they should have won the contract. However, the court did not award them any compensation for the loss of its profits for not being awarded the contract. Some may find this decision surprising, but it follows a long line of EU law authorities which require the bidder to prove not only a breach of the procurement regulations, but also that the breach was sufficiently serious. And this is known as the Frankovich test. The court held that the breach was not sufficiently serious because it had been inadvertent and had occurred in good faith. Brace Yourself appealed this decision to the Court of Appeal. It's a very involved judgment, and we only have time to cover it briefly today. In summary, the Court of Appeal rejected Brace Yourself's challenge. Brace Yourself had argued that the fact that the contract had been awarded to the wrong party demonstrated the breach was sufficiently serious. The Court of Appeal disagreed and confirmed it was still necessary to look at the nature of the breach itself. The Court of Appeal also rejected the argument that, unless there was bad faith, the state of mind of the contracting authority was irrelevant. And finally, the Court of Appeal rejected the argument that leaving Brace Yourself without an effective remedy for NHS's breach of the regulations meant that Frankovich should be disapplied. So the sufficiently serious breach test very much remains part of the legal test for determining damages, and this will be a great relief to contracting authorities. If an honest evaluation mistake is made, which is not sufficiently serious, that may avoid liability for damages, even if the wrong bidder is awarded the contract. And a complex consequence of this is how this development will impact on the decision a court may be called upon earlier in the proceedings as to whether the automatic suspension should be kept in place. If damages might not be awarded at trial, then arguably there may not be an adequate remedy, and the court may be less inclined to lift the automatic suspension. The next case, OCS Group Limited versus Community Health Partnership, involved a specific disclosure application. OCS had a bid for a substantial NHS cleaning contract worth £236 million over 9 years. They had lost by the tiniest of margins, 0.02%. Community Health Partnership provided early disclosure for the evaluator's notes for 2 specific questions that had been challenged. They refused disclosure of the rest of the evaluator's notes and the equivalent notes for the successful tenderer's bid. OCS were not satisfied, so they issued legal proceedings challenging the procurement award, and 5 days later issued an application for a specific disclosure order to force Community Health Partnership to provide the missing evaluator's notes. The court went through the fairly extensive case law in this area, including the leading case of Roche Diagnostics. The fundamental principle in procurement cases is that the challenger ought to be provided promptly with the essential information and documentation relating to the evaluation process actually carried out, so that an informed view can be taken of its fairness and legality. At the same time, the court needs to balance the bidder's disadvantage in its lack of knowledge about the evaluation process against the need to avoid fishing expeditions where bidders are searching for helpful disclosure for an otherwise weak case. Community Health Partnership claimed it had complied with its disclosure obligations, where OCS had made an arguable challenge as it had to the evaluation of 2 questions. Disclosure had been given. OCS were not entitled to disclosure of the rest of the evaluation notes, since the other questions had not been challenged, was the position the contracting authority took. The same applied to the note of the evaluation of the successful tenderer's bid, which they said was simply wrong. This was just a fishing expedition. The court rejected Community Health's arguments, emphasising, as in Roche Diagnostics, that the knowledge is stacked heavily in favour of the contracting authority. The disclosure test was essentially 2 points. First, had the claimant shown a sufficient prima facie case to justify making the order? And secondly, without the disclosure, were they able to decide whether to issue legal proceedings? The court concluded that because OCS had identified specific criticisms of 2 questions, it meant it was more likely they would be able to identify criticisms of the marking of the other questions. This was sufficient to warrant disclosure of the evaluation notes of the remainder of the questions. The court also assessed the reasons given in the contract award letter in respect to the successful tenderer's bid and concluded that they were not adequate to explain the score it received. Since OCS had already shown an arguable case on the evaluation of 2 of its questions, that meant the disclosure test was also met for the notes of the winning tenderer's evaluation. This was very much a victory for the bidder and will give confidence to bidders who have identified one or more deficiency in an evaluation to press for disclosure of full evaluation notes of both its and the successful bidder's evaluation notes. And finally, Teleperformance Contact Limited versus Secretary of State of the Home Department. Our final case today is another in a long line of applications to lift the automatic suspension. As mentioned earlier, if a bidder issues legal proceedings, currently before the contract is entered, the contracting authority's right to enter the contract is suspended. The contracting authority has the right to apply to court to lift the automatic suspension. In the large majority of cases, the contracting authority succeeds. Bidders therefore look for ways of differentiating their position from the standard case in order to keep the suspension in place. This was another very high value procurement involving 5 contracts worth £1.2 billion for the provision of global visa and citizenship services. The court applies the well-known American Sign test to decide whether the automatic suspension should be lifted. The 3 elements of the test are: is there a serious issue to be tried? Is damages an adequate remedy? And if not, where does the balance of convenience lie? In most cases, it is accepted that there is a serious issue to be tried, as the threshold is very low. Most cases fail because the court decides that the aggrieved bidder's losses can be compensated by a payment for their loss of profits. We'll have to see whether this approach changes following Brace Yourself. The challenge in this case, therefore, when trying to keep the automatic suspension in place, is to prove that damages would not be an adequate remedy. Teleperformance's argument was that the losses they would suffer if they were not awarded the contract would not only affect them, but also other companies in the group. Since those companies were not and could not be parties to the court proceedings, this would be irrecoverable loss. Hence, damages was not an adequate remedy. The court took a firm approach to this argument. Whilst exceptionally losses suffered by other members of a corporate group might be relevant consideration, this was not such a case. Teleperformance had chosen to arrange its business as a network of group companies. This had not been forced on them by the contracting authority. The contracting authority did not owe any duties to those other group companies, so it was not unjust to ignore their losses. In contrast, the court decided that the contracting authority would suffer losses if the contract was delayed, which could not be compensated in damages. The delay would also be contrary to the public interest. So, ending with a strong decision in favour of lifting the automatic suspension. That brings to an end this year's annual procurement update, which we hope you have found useful and interesting. Emma and my contact details are included on this slide, and if you do have any procurement questions, please feel free to send us an email. Thank you and goodbye.